Okay, we're on the record in the matter of the people of the state of Michigan versus Patrick Wilson, file number 23-00552FY, council appearance.
Thank you, Your Honor. Dale Coltrader on behalf of the people.
Good afternoon, Your Honor. John Abbott representing Patrick Wilson. Mr. Wilson is seated to my right.
Okay, today was the date and the time that was set for a preliminary examination. Are we ready to proceed?
This time, Your Honor, the people cannot meet their burden of proof.
The necessary witness is not here.
That's correct.
Mr. Abbott,
Move to dismiss, Your Honor.
motion to dismiss without prejudice is granted. That simply means, Mr. Wilson, can you hear me? That simply means the case will be dismissed today because the people are unable to proceed. The people do, however, have the right to reissue the charge if they do make contact with the necessary witness and the necessary witness is ready to proceed. Do you understand that? Okay, if that were the case, they would reissue and you would have to be rearranged and all that jazz. Do you have any questions at this time?
Okay.
Okay, we'll get you a copy of your dismissal and you'll be all set.
At this time, just for the record, under MCL 764.268, people object to destruction of fingerprint.
Okay, that will be noted on the document. Okay, thank you.
Yeah.
I'm gonna call this. Oh. I didn't pay those two.
Mr. Cartwright. Can you, on here, like the necessary witness stuff here, and then right under the bill.
Oh, yes, I'm sorry. Thank you.
Judge,
Yes.
I have Mr. Gang, we have Mr. Conley's case. The Truner, I do not have printed. Can I use an electronic exhibit and just show it on the screen for people's proposed exhibit 1? Or would you prefer that I print it?
You can put it on the screen, unless he has an objection to it.
I don't think Mr. Gang does.
I'll do with it. So
I don't.
It's just in color. Thank you, Judge.
No problem.
All right, Your
Have a good, you tried what?
Honor. Run an exam.
Have a good one.
Yeah.
Yeah, back to this. I need to ask Ms. Gail what's happening here. So, Hi, Ms. Gail, how are you? I'm doing well, thank you. I am calling about the file that you called with questions. I think it's Shirley Lopez. Calling about the Shirley Lopez file, I think it is what it is. Okay, we're on the record in the matter of the people of the state of Michigan versus Benjamin Conley, file number 23-01348, FY, council of parents.
Good afternoon, Your Honor. Kristen Roth on behalf of the people.
Good afternoon, Joseph Yang on behalf of Mr. Benjamin Conley Senior, and he's present to my right.
That was for the other file.
I don't think I have that file. I think that was for Wilson's file. Okay, today's the date and the time that's set for preliminary examination. Are we ready to proceed?
We are, Your Honor.
Okay, any preliminary matters?
I would ask for a mutual order of sequestration, but it looks like there's only court staff in the courtroom. My first witness is in the courtroom. We are ready to proceed.
Okay, sounds good. Is that officer witness of yours there?
Right here.
Okay, that's not one of your witnesses though?
No.
Okay, just making sure. Okay, you can call your first witness.
I would call Officer Ashley Anderson, Your Honor.
Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
I do, Your Honor.
Thank you. You can have a seat. And you can state your first and last name and spell both of them.
Yes. My first name is Ashley, Ashley. Last name is Anderson, Anderson.
Proceed, counsel.
Thank you. And what is your occupation?
I'm a police officer in Lansing Police Department.
And how long have you been a police officer?
For approximately 3 years.
Do you have any special assignments?
I do.
Were you working in your capacity as a police officer with the Lansing Police Department on April 28th of 2023?
I wasn't.
And did your duties call you to an area of Northrop and Kurt in the city of Lansing, county of Hingham?
I was there, but I was not called there. I was doing traffic enforcement in that area. On my own
Understood.
accord.
Understood. And when you were doing traffic enforcement, did you make any observations?
I did.
And can you please tell me about the observations you made that bring you to court today?
I observed a black sedan going westbound on Northrop, and it ran the stop sign at Kurt and Northrop at a high rate of speed.
And I guess, can you explain what that intersection is? At a typical four-way stop intersection?
It's a three-way stop intersection with Northrop being the main road. Kurt connects to it, and then there's three stop signs.
And when you made the observation of a vehicle going at a high rate of speed, what, if anything, did you do next?
I turned on my overhead lights and pulled out behind the vehicle and began to catch up to it.
And can you describe the vehicle that you observed going at a high rate of speed?
It was a black sedan and Audi.
And you said that you attempted to catch up to it. Was it your intent to conduct a traffic stop on that vehicle?
Yes,
Did you eventually catch up to that vehicle?
I did at the intersection of Northrop and Washington.
Did you make any observations of any of the occupants inside of the vehicle before you initiated the traffic stop?
Once I got up to the vehicle and noticed that it had stopped, I observed one occupant. It was a white male, and he was moving around very anxious and making furtive movements.
And can you describe the furtive movements, like where exactly was he gesturing?
So his left hand was down below the steering wheel. I could not see kind of where his left arm was reaching. I could see his right hand up on the steering wheel, and he was looking around with his head left and right, trying to figure out which way I was approaching.
After that vehicle was stopped, did you make contact with the driver?
I didn't.
And do you see someone in court that you identify as the driver? If so, can you please point to them and describe something that they're wearing?
Yes, ma'am. Mr. Conley over there wearing the gray dress.
Your Honor, may the record reflect the identification of the defendant.
Any objection?
No objection for purposes of prelim.
ID is noted.
And when you made contact with the defendant, I think you said he was the only occupant of that vehicle. What, if anything, did you do next?
I advised him of the reason for stop and requested his driver's license.
Did he provide you with a driver's license?
No, he said he did not have one.
At that point, did you ask him to step out of the vehicle?
I did.
And what, if anything, happened next?
I detained him in my patrol car and another officer arrived on scene, and that's when we began our investigation.
Did you pat the defendant down or conduct a pat down before placing him in your patrol car?
I did.
What, if anything, did you feel or find?
In one of his pockets, there was a large bulge, and I asked what it was, and I was told it was a large sum of money.
Did you at any point count or sort the denominations of that money?
I did not.
And then you said that Officer Barbanoff came to the scene. At what point did he arrive?
He arrived after I had detained Mr. Connolly, placed him in the patrol vehicle.
And what, if anything, is the next step in your investigation?
The next step was to run Mr. Connolly in lean and then also run the vehicle in lean, as it only had a dealer plate. It did not have a normal plate to it.
And after you ran the plate in lean, did it come back with any results?
It did. It came back as stolen out of East Lansing.
Your Honor, objection, Your Honor. If I could have a clarification of who ran the lien. There were two officers that were there. Just want to clarify who actually ran the lien.
Okay, you can clarify that.
Both officers ran it. I know Officer Barbanoff ran it first, and then I also ran it as a secondary.
And when you ran the VIN in lean, not only did you learn that it was stolen, but did that provide other information to you as well?
It did. It provided the registered owner's information.
And after you discovered and confirmed that the vehicle was stolen in lien, what, if anything, did you do next?
I conducted a search of the vehicle.
And at this point, is the defendant still detained?
Yes.
And where did you begin your search of the vehicle?
I started with the driver's side.
And prior to searching or while searching, did you have the opportunity to view the defendant?
I did, as Officer Barbanoff was talking to Mr. Conley's, another relative of his that was nearby. I saw Officer Barbanoff standing near the driver's side of the vehicle, and that's when I was watching Mr. Conley to see his reaction.
And can you describe for the record, Mr. Conley, the defendant's demeanor or behavior while the vehicle was being searched by Officer Barbanoff?
I observed that he was very agitated with Officer Barbanoff standing in the door frame of the driver's side, was constantly looking at Officer Barbanoff and was fidgeting around.
Based on those observations that you made, what, if anything, did you do?
I then proceeded to do the search myself and found a crystal-like substance in the driver's side door.
So you found what?
A crystal-like substance
Where?
in the driver's side door.
Thank you.
And when you found that crystal-like substance, was it in the door, like the pocket of the door?
Yes, ma'am, it was.
And was that the same area that you observed the defendant making his furtive movements earlier in the night?
Yes, it was.
And was there anything else with that crystal-like substance when you searched?
There was another baggie of a brownish powdery substance.
Did you observe any other narcotic packaging or tools of any kind?
So both the substances were in small plastic baggies, and then I did also find a scale and then a Best Western scan card typically that's used for cutting different substances.
And where were those two items located?
They were in the center console.
And after locating that crystal-like substance, did you have an opportunity at some point to conduct a true narc test on that substance?
Yes, ma'am.
Your Honor. I have the screen. I'm showing you People's Proposed Exhibit 1.
Let's see, I may have to make you. Close. You're not in here. Let's see, it's not loud. Screen sharing is not loud, and I'm not sure why. Can you log into Zoom?
What is the meeting ID?
876-493-1931.
Thank you.
No problem. So we're gonna let you share now.
Well, oh. I am showing you People's Proposed Exhibit 1. Can you please describe for the record what this exhibit is?
So this is our true narc testing device that we use. And this was the scan result of the white crystal-like substance. This is the result of that scan.
Does this fairly and accurately depict the scan that you did in connection with this case?
Yes, it is.
Your Honor, I'd move for the admission of People's Proposed Exhibit 1.
Any objections?
Not for the purposes of printing.
People's one is admitted.
Thank you, Your Honor. And Officer Anderson, can you state for the record what the result was of the true narc test that you did on that substance you found in the vehicle?
Yes, it came back as methamphetamine.
Thank you. And after you conducted the search and located the methamphetamine, the scale, and the card, what, if anything, did you do next?
I read this from his mind.
And did he agree to speak? Did he waive those rights and agree to speak with you?
Yes.
And did he tell you anything about the stolen car?
Stated that he was driving around for his daughter to test it out because it wasn't working that well, and that it was purchased from a known stolen vehicle salesman, guy who commonly sells stolen vehicles.
I just need clarification. He said that it was purchased from a guy who is known to sell stolen vehicles?
Yes, Your Honor.
Or did he say the person's name?
He did give a name.
So I'm trying to figure out if he said, I purchased this from a person who's known to steal vehicles, or is that your interpretation of what he said?
No, he said that the vehicle was his daughter's and that he was just driving it and that she purchased it from an individual who is known to sell stolen vehicles.
Very good, thank you.
Is that the explanation that he gave once you confronted him with the fact that it was stolen?
Yes.
Is there anything else noteworthy discovered in the vehicle?
Not that I can remember.
And was the registered owner of the vehicle able to come to the scene and retrieve his car?
They were, yes.
I think Brennan.
Cross-examination.
Officer Anderson, my name is Joseph. If I go too fast or you need me to repeat something, please let me know. All right, all right, clear, again, just to clarify, you actually ran the lien yourself, is that correct?
I did.
All right. And did you make contact with the registered owner of the vehicle, or did somebody else make contact?
Somebody else made contact with
Okay,
Rich.
did you interview that person at all?
I did not.
Okay. Did you obtain the title to the vehicle?
I did not.
Okay. Did you obtain the keys to the vehicle?
I did not.
Did you take a statement from anybody else besides Mr. Tom?
No, sorry.
Okay. Was the statement that you said, or that you stated about earlier, was that recorded on your body cam?
It was.
What time of day was this?
It was, I believe I initiated the traffic stop at 12:54 at night.
Okay, so it was dark out.
It was dark out, correct?
And just to clarify, did he give a name of the person that he purchased the vehicle from, or did his daughter purchase the vehicle from? Or did he just say it was somebody? If you remember, if you recall.
I remember a name being given, and I believe that it was the person that they got the vehicle from.
Okay, so was that person ever interviewed?
No,
To your
that person was not.
Okay, did you do any subsequent investigation into this at all?
No, I did not.
So did you receive Mr. Conley's permission to search the vehicle?
No.
Okay, and the basis of searching the vehicle was,
If it was stolen, and I was gonna be towing it to the search incident.
okay.
Your voice dropped, so you said because it was stolen and what happened?
Search incident to arrest.
Um, Are you aware if anybody else interviewed the registered owner of the vehicle?
I'm not.
You're not, okay.
Other than possibly the East Lansing, if they had taken the primary.
Primary report, okay. Do you know if the owners ever I take it back, you already answered that question. Give me one moment. Did you interview his daughter at all?
I did not see.
You did not speak with her? Okay. Are you aware of which officer obtained the title from his daughter? You're not sure?
No.
Okay. Further questions, Your Honor?
You said it was an Audi vehicle. Do you know what year the vehicle was?
After running it, it was a 2009.
2009. And you said, I think I missed the part. Did you say his daughter did have a title, or you're not aware?
I was not aware of any title.
Okay, sounds good. Redirect.
Nothing, Your Honor.
Thank you, Officer Anderson.
Thank you. Your Honor.
No problem. And you have another witness?
I do not, Your Honor.
Okay. The defense calling any witnesses today?
No proofs for the defense, Your Honor.
Okay, you can proceed to argument.
Thank you, Your Honor. Judge, I'm asking the court to bind over as charged. We've heard Officer Anderson testify to the elements of both count 1 and count 2, certainly by a probable cause standard. Defendant is charged with possession of methamphetamine. We heard Officer Anderson testify that she conducted a traffic stop. This defendant was traveling at a very high rate of speed. Officer Anderson, while stopping the vehicle and conducting that traffic stop, observed the defendant to make furtive movements and gestures with his left hand on the left side. And we heard Officer Anderson later testify that she did in fact search the driver's side door and located what was true narc positive methamphetamine in the driver door, which certainly corroborates where the defendant was gesturing. Your Honor, this is a stolen vehicle. The defendant either had knowledge, he either knew or had reason to know. He did make statements to Officer Anderson that this vehicle was allegedly purchased from someone who is known to sell stolen cars, assuming that statement was made to explain away the fact that the VIN was stolen. Nevertheless, certainly establishes knowledge or reason to know that the vehicle was stolen. That was verified and leaned to be stolen. The defendant was the sole and only occupant of that vehicle. So certainly, Your Honor, I believe that the evidence today has shown by probable cause the counts 1 and counts 2. So I would ask the court to find over.
Thank you, Your Honor. I'll address first the receiving and concealing. Your Honor, the testimony was that the officer looked at Lean and Lean identified that the vehicle was stolen. I would ask that this court only take that information as to what the officer did next, not as for the truth of the matter stated. There's no other evidence that the car was stolen except for what was in Lean. It could be bad information, it could be incorrect information. There was no other information for that. Therefore, I would ask that the receiving and concealing not be bound over on this because the people have not presented any evidence besides what was in Lean. The alleged owner was there. They did not get a statement from the alleged owner. The alleged owner is not here to give a statement. So the people have not met the burden to show that the vehicle itself was stolen, was in fact stolen. As far as the substances that were found, if the vehicle was stolen, there has been no testimony to show that my client had knowledge that those substances were there, and that had no knowledge of that. Therefore, the possession of the controlled substances should not be bound over as well. Thank you, Your Honor.
Thank you. Maybe you argue.
I just briefly, Your Honor. The evidence certainly shows that this defendant was in possession of the stolen vehicle and he had knowledge, reason to know. Registered owners did come to the scene. There's no to recover their vehicle. Certainly, if they had let this defendant borrow it, or if somehow he had a legal right to it, arguably they would not be coming to the scene to recover their stolen car. So I think the inferences there stand for themselves, Your Honor. Thank you.
Today was the date set for preliminary examination, and the burden is on the prosecution to establish that there's sufficient probable cause that a crime was committed and probable cause sufficient to charge you with those crimes. This is not a trial, so the burden is not on to prove each element beyond a reasonable doubt. That's for the trier of fact. This is to meet a burden of more than mere suspicion that a crime was committed and that you committed the crime. And so that's a flexible burden. It's based on the facts and information presented at today's hearing. And it's based on the use of common sense when hearing or evaluating that evidence. We have a complaint here where the people have charged you with count 1, controlled substance possession of methamphetamine or ecstasy, and a count 2, stolen property, receiving and concealing motor vehicle. Count 1 at trial would require the people to prove the elements beyond a reasonable doubt that the person that the defendant possessed the controlled substance, in this case being methamphetamine, and that second, the defendant knew that he possessed a controlled substance, and third, that the substance that the defendant possessed was a mixture that weighed, and they would need to prove a certain weight at the time of trial. Possession in this context will be defined by the jury instructions as a person not necessarily needing ownership, but possession means that the person has actual physical control of the substance or thing, as I do holding this pen in my hand here. A person has the right to control the substance or thing, even though it is in a different room or place, is also an option to prove or define the meaning of possession. Possession may be sole, where one person alone possesses the substance or thing, or possession may be joint, where two or more people share possession. It is not enough if the defendant merely knew about the substance, that being methamphetamine, or the thing, and the defendant possessed the substance or thing only if he had control of it or the right to control it, either alone or together with someone else. So today we had testimony from Officer Ashley Anderson. She indicated that on or about April 28, 2023, in the area upon South Washington in Northrop, City of Lansing, Ingham County, State of Michigan, that she noticed a vehicle or observed a vehicle that described as a black sedan going at a high rate of speed. She identified that vehicle to be an Audi type vehicle. This was a three-way stop intersection. She did eventually effectuate a traffic stop. Upon effectuating that stop, she testified that she noticed the defendant making furtive movements or gestures towards the left side or with his left hand. Defendant was detained upon making that stop, and the officer's patrol vehicle, a pat down search was performed. She indicated that there was a large bulk in one pocket, that the defendant told her it was a large sum of money. The vehicle was then ran into the law enforcement information network, which it came back via VIN because there was no plate, that the vehicle was stolen out of East Lansing. Officers conducted a search of the vehicle. I believe Officer Anderson observed another officer at that time making a search, but the defendant appeared annoyed and or fidgeting, and she switched and allowed so she could go and complete the search. She was able to search in the area on the left side of the vehicle, which would have been the console and the driver's side door, and stated that she located or found a crystallized substance in the driver's side door, that area being consistent with the area in which the defendant was making the furtive movements during the traffic stop. There was another baggie of a brown powdery substance located. The substance found in the door, the crystallized substance that is, was TrueNarc tested. That was evidence presented in People's Exhibit 1, and it tested positive for methamphetamine. When questioned about the vehicle coming back as stolen, Mr. Conley allegedly told the officer that he was test driving or driving the vehicle on behalf of his daughter, who had purchased it. And he stated allegedly that she purchased it from a person known to sell stolen vehicles. The owners of the vehicle later appeared to recover their vehicle. We have first a question of whether or not there's sufficient probable cause as to controlled substance possession of methamphetamine. In review of the elements that need to be proven at trial, let's see. We do have a TrueNarc testing that this was in fact methamphetamine. Whether or not the defendant knew or knowingly possessed it, I think there's sufficient probable cause that he knew or had knowledge that there was methamphetamine in that area, because based on the totality of the circumstances and consideration here, we have an officer trying to make stops. There's further movements in that area of the vehicle, and upon search of that area, they recover the contraband or the alleged contraband in that time. And so also during the search, there's a large amount of money in the pocket of the defendant, and taking those things in its entirety, someone carrying a large amount of money and then making further movements upon a traffic stop, and then the officer later finding a controlled substance, it's an indication of possibility that there are some possession in or distributing of of narcotics going on. So there's sufficient probable cause as to count one. And so count one, controlled substance possession of methamphetamine and SD will be bound over to the circuit court. Count two, stolen property, receiving, concealing motor vehicle. Officers ran that vehicle, which did not have a plate or even a temporary plate, and had to run it through by the VIN number into law enforcement information network. I will note that although Mr. Yang is asking the court to only consider that as it relates to what the officer did next, there was no objection as to hearsay when that was entered. That information was entered. Nonetheless, I probably would have overruled the objection anyways after further foundation being laid, because that information for a probable cause standard I deem sufficient to demonstrate to the court that the officers believed that the vehicle was stolen. That taken into account that when they brought that information to the defendant allegedly made a statement stating that the vehicle was purchased from a person that he personally knows to sell stolen vehicles. Then, if we take it a step further, we have the alleged owners coming to pick up the vehicle. So the court is satisfied that as to count two, stolen property, receiving, and concealing, that the defendant knew or had reason to know that the vehicle was stolen and that he was in possession of that vehicle. That count two will be bound over to the circuit court for further prosecution. Find over date will be July 12th. You do not need to appear in circuit court on that date. That's the date that they'll get the file from this court. Your next court date will be a pre-trial in circuit court. Mr. Yang will be made aware of that. He'll be in contact with you. Do you have any questions today, Mr. Conley? Is it Benjamin Conley Senior?
Yes, ma'am.
Okay, I don't see that on here. We need to make sure that's clear in the judicial information system.
Listen, the senior.
Okay, very good.
Thank you, Judge.
No problem. Bond was set at 5,000, 10%. That will continue. Any additional matters for the record?
Now on behalf of the people.
Nothing on behalf of the defense, Your Honor. Thank you.
Thank you. You're all set.
Okay.
You know, everything wrong.